Picture a family in Lagos, Nigeria. A mother waiting for her visa interview for over a year, finally called in, finally sitting across from a consular officer, finally hearing the words, "Your case has been approved." And then, instead of a stamp in her passport, she's handed a piece of paper telling her the visa itself cannot actually be issued. Not denied, not approved, just frozen, indefinitely, for reasons that have nothing to do with anything she did. That is the reality for families from 75 different countries right now, and most of them have no idea when or if that will change. Welcome back to US Visa News Hub. I'm Mr. Burhan, and if you're not subscribed yet, this is exactly the kind of update you don't want to miss. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. On January 14, 2026, the State Department announced that, effective January 21, 2026, it would pause the actual issuance of immigrant visas, meaning green cards processed through US embassies and consulates abroad, for nationals of 75 specific countries. The State Department posted publicly that the freeze would remain in place, in their words, until the US can ensure that new immigrants will not extract wealth from the American people, framing this entirely around public charge concerns. The idea that applicants from these particular countries are, according to the government, at high risk of relying on US public benefits after arriving. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. Before going further, I want to clear up something that's genuinely confused a lot of people, including some immigration professionals. This 75-country pause is a completely separate policy from the 39-country travel ban and USCIS hold and review policy that took effect around the same time, in January 2026, under a different presidential proclamation focused on national security. Those two policies happen to launch within weeks of each other. Some countries appear on both lists, and they're often talked about together, but they're run by different agencies for different stated reasons, and they've had very different legal outcomes. The 39-country USCIS policy was actually blocked by a federal court in Rhode Island back in June 2026, which we covered on this channel. This 75-country State Department pause is a separate matter. It operates entirely differently, and as of the most recent information available, it remains largely in effect. Let's talk about exactly what this pause does and doesn't do, because the details matter enormously if you're affected. This policy applies only to immigrant visas, meaning visas that lead to lawful permanent residence, whether through family sponsorship or employment. It does not affect non-immigrant visas at all, so F1 student visas, J1 exchange visas, H1B work visas, TN, O1, and tourist B1, B2 visas are completely unaffected by this specific policy. If you already hold a green card, this pause does not revoke it. Existing immigrant visas and permanent residence already granted remain valid. And if you're a dual national who can apply using a passport from a country not on this list, you generally remain exempt from this particular pause. Here's what actually happens if you're affected, and this is exactly what happened to that mother in our opening story. Consulates in the 75 designated countries are continuing to accept new immigrant visa applications, and they're continuing to schedule and conduct interviews. What they're not doing is actually issuing the visa at the end of that process. In most cases, after your interview, the consular officer places your case into what's called 221G administrative processing, or issues a formal refusal under that same provision. That keeps your case technically alive and open, rather than denied outright, but it leaves you in a genuine holding pattern with no announced end date, waiting for either the broader policy to be lifted or for your specific case to somehow qualify for an exception. There are some limited exceptions built into this policy. Certain diplomatic visas, special immigrant visas for people who worked for the US government, lawful permanent residents themselves, and participants in major sporting events have specific carve-outs. It's worth noting that under a related, connected proclamation, some previously available exceptions, including certain immediate family immigrant visas and Afghan special immigrant visas, are reportedly no longer available the way they once were, which has added another layer of difficulty for families who were previously counting on those specific pathways. Now, has anyone actually challenged this in court? Yes. On February 2, 2026, a federal lawsuit was filed arguing that this policy exceeds the State Department's legal authority and conflicts with the government's own long-standing public charge standards and procedures. That litigation has already produced at least one concrete result. A federal district judge, Ann Traum, issued an injunction ordering the State Department to actually adjudicate the visa applications of two specific plaintiffs, both nationals of the Democratic Republic of the Congo, finding that the policy likely violated the Administrative Procedure Act by contradicting the visa adjudication framework Congress established and improperly stripping away the individualized discretion. Consular officers are supposed to exercise case by case. It's important to understand what that ruling did and didn't do. It provided relief to those two specific plaintiffs in that specific case. It was not a nationwide injunction that lifted the pause for everyone from all 75 countries. So while this litigation shows the policy is facing real legal challenges, and while it may eventually expand to broader relief, as of now the pause itself remains largely in place for the vast majority of affected applicants, including families like the one we described at the start of this video, still waiting, still checking their mail, still not knowing when their case will finally move. So, what should you actually do if this affects you or someone in your family? First, understand clearly whether you're actually impacted. This only affects immigrant visa issuance abroad for nationals of the 75 listed countries. It does not affect non-immigrant visas, and it does not affect people already inside the United States adjusting status through USCIS via Form 1485, since that's a separate process governed by different rules. Second, if you have an interview scheduled, attend it. Consulates are continuing to conduct interviews, and skipping yours won't help your case move forward once the pause eventually lifts. Third, if your case has already been placed into 221G, administrative processing, understand that this is where your case is likely to sit for an undetermined period, and there's currently no official timeline for when that will change. Fourth, if you believe you might qualify for one of the limited exceptions, dual nationality with an unaffected passport, a special immigrant visa category, or another carve-out, this is exactly the kind of nuanced situation where consulting directly with an immigration attorney familiar with this specific policy is worth the investment, rather than assuming your case doesn't qualify. And fifth, given that this policy is actively being litigated, it's worth periodically checking in with your attorney or monitoring reliable immigration news sources for updates, since court rulings in this area could shift relatively quickly and unpredictably. The bottom line here, if you're a national of one of these 75 countries with a pending immigrant visa application abroad, your case is very likely sitting in limbo right now, 7 months after this policy took effect, with no official end date in sight, even though a legal challenge is actively working its way through federal court. This is a genuinely difficult, uncertain situation for the families involved, and staying informed about both the policy itself and the ongoing litigation is the best way to be ready to act quickly if and when something changes. If this was helpful, share it with anyone you know who might be affected by this pause, and subscribe to US Visa News Hub so you don't miss updates on this litigation or the broader policy. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.